This is video 1 for weeks 5 to 6 of the introductory course, and it's a screenshot of posting 5 sources of the law, and we're switching gears, if you will. We're now going into a different area. We've been looking previously in our first 4 weeks at lawyers and paralegals. What does the practice of law mean? What rules govern attorneys' conduct that paralegals should be aware of, etc., etc. But we're now getting into an area where we're taking a look at some of the what we could call substantive law. And our first order of business, and I think this is what anybody going into the study of the law, be it from the point of view of a paralegal or an attorney, should be considering at the introductory level. Where do the rules of law come from? And what I've identified for you in this posting are the 5 sources of legal authority. And what I'm saying to you is, if you would identify any rule of law in the United States, it could be traced back to one of these 5 sources of authority. And so we've identified the 5 sources as constitutional authority, judicial authority, legislative authority, executive authority, and administrative authority. And let's just bring it down to earth even at this point. When I say constitutional authority, I'm just saying that there are some rules of law that can be traced back to the Constitution. And we're going to learn that not only is there a U.S. Constitution, but there is different state constitutions. But let's stick with the U.S. Constitution. A rule of law, free speech. We can find that in the First Amendment to the U.S. Constitution. Judicial authority, and this is, to me, somewhat interesting. It maybe cuts against the grain of a sort of primitive view of looking at things when we look back at our earlier education, because we were sort of taught, well, legislatures make the law, the executive carries out the law, and the judges interpret the law, or something like that. But what I'm telling you is that some rules of law are traced back to the judges. Judges in our system, or the system of law in the U.S., are lawmakers. And so we want to be aware of that, and we're going to be looking into it. Legislative authority might be the one that you're aware of, that the national legislature, the Congress, or the state legislature, from time to time, they will pass laws. And that could be seen, for example, if you're taking the crimes course, we're looking at the New York penal law. That's a law or a series of, or a set of rules of law that come from the legislature. Executive authority. At the national level, we have the president, and at the state level, we have the governor, and we have other executives at other levels of government. But the executive, the president makes laws. And in recent times, be it a Democrat or a Republican president, you've perhaps seen in the media or heard in the media about executive orders. Well, that's an example of the president making law. For example, former President Obama issued executive orders regarding immigration, the DACA and the DAPA rules. President Trump tried to then issue executive orders doing away with or suspending DACA. So we have the executive as a lawmaker. Certainly in this time of COVID, governors in the United States, including Governor Cuomo, issued shutdown orders that had the force of law, mask requirements that had the force of law, and so on. And then finally, as we're just taking this sort of introductory look, we have administrative authority. At the state and federal level, we have administrative agencies. And most of us in our wallet have a New York State driver's license. Well, we know that we can run into hassles with the State Department of Motor Vehicles if we have too many points on our license and so on. Some of us may have a relative who owns a business that sells liquor. Well, that relative is very much aware of the authority and the rules and regulations of the State Liquor Authority. If you have a young child, you may be sending her or him to a daycare. That daycare is licensed through the state of New York and subject to regulations that have been handed down by the New York State Department of Children and Family Services. So all of these 5 areas are sources of the law. And when we go through this from time to time, I'm going to try to bring this down to earth. So this is going to be more than just sort of an academic exercise, like this is some political science course. We're going to maybe take a look at where the so-called rubber meets the road as we go through this. But let's begin with constitutional authority, and as I say, it belongs at the top of the list, we could say, because the Constitution creates the context in which the other 4 sources operate. And indeed, when the rules of law come from any of the other 4 sources and are in conflict with the Constitution, they are often declared null and void on the ground that they are unconstitutional. Now, we have a 3-hour course in constitutional law now in the curriculum where this constitutional authority presumably is explored in some depth, but I do want to make a few observations about constitutional authority. But let me just stop here and suggest something, by the way. When I say that rules of law that come from any one of the other 4 sources and are in conflict with the Constitution are often declared null and void on the ground they are unconstitutional, who does that? And, of course, what we're going to discover, if you haven't already discovered, it's the United States Supreme Court. So perhaps the courts, or the United States Supreme Court, at least belongs at the top of the list, because over the years the Supreme Court, and it's been unchallenged, has made the determination that it has the last word on what the Constitution means. But we do have constitutional authority, and I've given you some examples, the Bill of Rights, and I point out the judicial review, Marbury versus Madison. I also point out the various states have constitutions. And I know that for myself, I've done a fair amount of work with municipal governments and school districts and so on over the years. And sometimes we bump into a legal rule that can be traced back to the New York State Constitution. For example, the state constitution has various rules about the state civil service system, and sometimes those are the rules that animate, or if you will, inform the legal issues we're dealing with. And I'll talk more about constitutional authority later, but as we're just going through this list, I'd like to get down to judicial authority. And as I've suggested just a moment ago, judges, it could be argued, are the most important lawmakers in the U.S., when we keep in mind the awesome power of the United States Supreme Court. But in any event, we can say this at this point. Judges create the law in 2 different ways: when they interpret the other sources of legal authority, and when they engage in something that I'm referring to as the common law process. So let's consider this. I say that judges create legal rules when they interpret the other sources of legal authority. And I think we have this very accurate statement that we don't always consider. The power to interpret is the power to create. When we have a legal rule that requires interpretation and a judge or a court interprets that legal rule, the legal rule has a greater meaning after the interpretation than it did before the interpretation, and to that extent the judge or judges have made law. And to continue with this awesome word, an awesome example of how the power to create emerges from the power to interpret is a 1965 case of the United States Supreme Court decision, Griswold versus Connecticut. Let's just consider this case. It's kind of interesting. In that case, there was a Connecticut law at issue that the legislature, the duly elected legislature, by the majority of the people who voted in Connecticut, had kept this law on the books, as we like to say, for years. And the law said that it was a crime to sell or even impart information on the use of birth control products, be it condoms or IUDs, whatever, and how to use them. So Planned Parenthood in Connecticut challenged the constitutionality of the law. In other words, the claim was made that this Connecticut law was unconstitutional. And the majority of the court in Griswold versus Connecticut upheld the challenge, meaning that they found that the law was unconstitutional because it violated, and they sort of try to keep it narrowed by saying a married couple's constitutional right to privacy. So, full stop. Question, where can the constitutional right to privacy be found? And our answer would be, well, of course, in the Constitution. But you can read the first word of the Constitution to the last word through its different amendments, and nowhere in that reading will you see that there's a constitutional right to privacy that has been set forth. And yet in Griswold versus Connecticut, by interpreting other parts, by necessity other parts of the Constitution, and they did it in a few ways, the court came up with this constitutional right to privacy. One of the approach was that it could be found in a number of penumbras or shadows of explicit constitutional rights. And one of the dissenting judges, in other words, this judge disagreed with the majority, stated he valued his privacy as much as the next person, but he couldn't find the constitutional rights set forth in the Constitution. In any event, that seems to me, the Griswold case, to be a very significant example of how the power to interpret is the power to create. And in Griswold, I'm going to suggest the court created a constitutional right. So the argument could be the right wasn't in the Constitution until the court said it was, which seems to me to be an act of creation. And just historically, it was that right of privacy in Griswold that led to the court's decision in Roe versus Wade, in which the court found that a Texas statute that severely restricted abortions violated a woman's constitutional right to privacy. And then, as I point out, the creation of legal rules by judicial interpretation isn't by any means limited to the Supreme Court's interpretation of the U.S. Constitution. There's a number of instances where there's a legal rule or, from the legislature, from the administrative agency, or maybe an executive authority, where there's a requirement of interpretation, and we know more about the law after there's been the interpretation than before. And I focus on New York law about suitable age and discretion for service of a summons and use that as an example. And I'll stop the video at this point.